is also being done at the moment. So this is how the government has brought about certain changes to the recruitment of TN safety officers rules. The government, you would recollect somewhere in the year 2018-19, had amended the Tamil Nadu Shops Act, providing for registration. Most other Shops Act in other states already have registration. Tamil Nadu did not have. Following this, a draft rules, this has not come into force. The rules are with regard to providing for online registration and issuance of online certificate. Similarly, if you want to amend the certificate, you can amend it. The existing establishments, what they need to do on an online part of it. The other two parts that have come about with this is that every establishment would need to have a first aid box, and the fine for non-compliance under these rules have been enhanced from rupees 50 to rupees 2,000 per count. Under the ESA Act, various provisions of the ESA Act have now been extended to the Nilgiris district in Tamil Nadu, as well as certain aspects in Uttar Pradesh as well. They have done it. Under Section 17 of the EPF Act, employers can seek exemption for their establishment, so they can keep separate trust through which they can run the provident fund for their employees. So now the provident fund, what is required to be done, they have put in an SOP, and what is very crucial in this SOP is they have categorized it into three different kinds of aspects to be seen during the audits. It's more a checklist for their own officers, but the SOP is also something that every establishment which has its own exempted trust should be looking at to and see what they need to do. So some cases they say that you can cancel the exemption itself. So they categorize those non-compliances as category A. Then where the direction can be issued for rectification of deficiency as category B. And category C is where merely an advisory for the establishment to be more vigilant. So when A, B, or C arises has been categorized in this SOP with a priority matrix that has been given. So if you are one of the exempted establishments, you would need to look into the especially category A and be careful so that there is no show cause issued to you for cancellation of exemption. This is a very minor issue, but up to 100 rupees, they were not claiming interest. Even if there is a belated payment in a contribution, 6 months period, if there is. Now they have increased it to 300 rupees. So up to 300 rupees of interest, if there be any delay. So maybe 1 or 2 days delay, the interest component may not be asked by the ESI if it is less than 300 rupees per contribution period. This is more under the General Provident Fund. This is not PF Act. The government has said that what is the rate to be followed for the next quarter. Moving to the quiz question for this month. The question is whether in terms of the provisions of the Contract Labour Act, employment of contract labor and core activities is prohibited in state of Tamil Nadu. Please do put in your answers in the chat box as to whether it's a yes or a no, what you think is the right answer. In the across the globe segment, to what extent dismissals are upheld in abroad is something that we could see. This is a UK-based lawsuit where the employee was dismissed. The charge against the employee was he had ordered for 2 sandwiches, 2 pastas, 2 coffees, meaning he had one was his own expense, the other was a friend whom he had taken along. So he's not supposed to claim for the partner, the second person, but he made a claim for that. But once the employer came to know, saying that his claim was misclaimed, they had dismissed him from service. Um, challenging the dismissal, he had filed the suit. The court there dismissed it, saying he should not have asked for payment for the second sandwich, second pasta, second coffee, and held the dismissal was justified. Whether Indian courts would take such a stringent view of things is something that we need to see, which normally doesn't happen in India. This again is more as a caution. We thought we should put in this news here. One of the well-known coffee chains, their recipes got revealed in a social media posting. So around 41 shakes and coffees recipes were given out. And that really shook the business. Now people were trying to make things at home based on the uh, ingredients to be done, the recipes that was given. So the question here is your establishment, one, is to keep the confidential information. Two, if the confidential information were to be leaked in social media, do you have any kind of protection against such employees leaking confidential information? So that is something you may need to think about. So we found this to be a very interesting provision in an old enactment of the year 1934, which requires even kites and balloons near aircraft require permission to fly. So we just thought how at that point of time maybe they had some reason to put it in, but today does it make any sense for this act to continue? It's the latest judgment of the Supreme Court, which uh, goes more on a fact that a person was initially recruited as an assistant engineer by an electricity board. He was then not offered the employment because he had color blindness. So, being an engineer, he was required to know the three colors that they use in the coding of wires, and but therefore they terminated his services. Rather, they didn't proceed with the employment. The Supreme Court has said, no, you should have placed him in some other place. And that is the kind of a benevolent approach the Supreme Court had taken up in this case. The next case uh, pertains to under the Provident Fund Act of a school. The question that arose was, were there 20 employees and how to count the 20 employees? The contention of the school was it had a conductor and a driver, which was not on their roles, but it was a third party establishment. And again, the chairman of the school need not be taken into. There was no relationship. But the High Court dismissed the petitions and held that the school. So when you take 20 persons, it said that your chairman, who's a salaried person, would also be need to be taken into account, and that no documents were filed with regard to the drivers and conductors, and therefore they were rightly included in the lack of material. So it is very crucial that you furnish records whenever any kind of inquiry is called upon to disprove the contentions of Provident Fund or authorities like under the ESA Act, etc. Our answer to the quiz question is no. Only Andhra Pradesh alone has core and non-core. Tamil Nadu doesn't have. And the provisions of the Act also permits engagement of contract labor and core activities, provided you're able to get a registration and license for it. It's a topic by itself to be discussed as to when you could engage contract labor and core activities. So I'm not going into it, but there is no prohibition in law. That's the aspect which we wanted to drive home with this question. In the Lex Post segment, we just thought of bringing in a recent judgment of the Supreme Court, where they're given directions. These are more to the government on establishing the LCCs in different districts, because the local committees would need to come in. So many districts still don't have local committees where domestic workers can complain, or a lot of other people would also, something that happens in public, it could also be complained about. So the Supreme Court has given directions to ensure that local committees are notified and formed by the concerned districts. This is the complaints calendar. We would be sharing it with you. Those who have joined in today should get the PPT and you will be able to go into the complaints calendar. The last segment for the day is our knowledge corner. We are touching upon the topic of financial liability of directors under various labor statutes. We are just giving you a bird's eye view of it. We first shall look at a director under the ESA Act, what is the liability. The term principal employer has been defined under section 217. Moving with that is a case where a director of the company was sought to be proceeded with, but the Supreme Court in this case held that the company is the employer and the directors are the employees of the company, and hence the directors cannot be held liable to pay the ESA contribution. A similar Madras High Court held that directors are not owners and allowed the writ petition of the petitioner, stating that directors cannot be held personally liable and personal properties cannot be attached, and held that the respondents can proceed only against the company. Under the EPF Act, also there are similar provisions. Who is an employer is defined under Section 2E of the EPF Act. The question is whether the directors can be considered as employers. In this judgment, it was held by the Calcutta High Court that the directors are not the employees to be prosecuted for non-payment of employee contribution. These are all the line of judgments where the magistrate again convicts, but the High Court observed that they are only responsible, and they said that whether the concerned director can be prosecuted, pleadings and evidence would need to be shown, and in that case, it was not available, and therefore they quashed the proceedings. Under the Minimum Wages Act, similarly, was a case where again employer is being defined under the Act. A labor enforcement officer was trying to prosecute a director, and they said that a director or somebody cannot be prosecuted unless it can be shown that the offense in question was committed with their consent or connivance, merely because the vicarious liability cannot be fastened unless the labor enforcing authorities are able to show it was done wantonly and the persons who were liable were the persons against whom the prosecution was brought in. They had full knowledge about the contravention. Factories Act stands at a slightly different level because the occupier under Section 2N has been already interpreted by the Supreme Court to mean only a director of a company. But then again, how far can it be fastened? So director is liable, but the factory inspectorate would need to prove that it is owing to the director that this happened. And in one case alone, this has been struck down. And that's the case that we thought we will try to show here. So there are judgments which do tend, and more of it looks on factual aspects. So it is not only the law, but factually also there are certain parameters to be seen under various labor enactments. In some circumstances, the employers are held to be, directors are not held to be employees and they are not made liable. But there are some circumstances like the Factories Act where they are liable, but then is the authorities able to prove that the violations happened either knowingly or with their connivance or knowledge. So these are the different ways in which, if prosecutions are there against directors, it can be defended. So this is our knowledge corner, and with that, we come to the end of this month's labor law update. We again hope to meet you on 25th November at 4 p.m. Thank you.